A very good morning. For the second time, we are having this good morning, right? So, a quick revisit. I wouldn't say recap because we didn't see anything in the last class. Okay, of what we have seen in the last introductory session is what is the syllabus, which is again displayed to you, and we just went through how we are going to give an approach towards the subject. From commercial laws, how it is going to be. Industrial laws, it is purely on the applicability on other parts. Companies Act, we are going to see a part of Companies Act which requires, because Companies Act is going to be new to all of us, right? So that, and finally ethics and emotional intelligence, which is purely theoretical to apply our personal lives and see, right? Value judgments, yes or no, when you have to decide. So that is what the entire syllabus is about. Now we will be starting with the which one? First, introduction to law and legal systems. What are the parts which we are going to see in it? Foundation would have already seen part of it, and here also we are going to reiterate few points which we have already seen in foundation. Apart from this, they have given individual importance to articles. Certain articles has been given with much information. Okay, so foundation we didn't go through in depth. Few articles here in intermediate has been given. We'll see what it is, and it is not nothing new. You know it as a practice. Freedom of speech. Do you know it was there? How? You read articles? You read the article? No. It has been part of our civics, social studies from school. Now we are just going to the next level. What is the source of it? We have been seeing that yes, freedom of speech is there for every citizen of India. So, what is the freedom of speech? What is the freedom of speech? Not speaking during the classes. What is freedom of speech? You can speak anywhere. Unless thing opinion. What was the other answer? To speak for basic rights. Otherwise, you should not speak. Only for rights you should speak, is it? Right. So I need some, I'm deprived of some my rights. I should demand that. So I can do that, right? And simply, I have a feeling to express. Can I do that freely without any hesitation? Yes, I can do that. So that is what Madam says, right? So is it an very free right? Okay, I can speak whatever I want. Then is there any restrictions towards it? Whether any of our social studies said that freedom of speech is there subject to certain restrictions? They have just said you have the freedom of speech and expression. You can speak, express whatever you want. But iconically, article has put on some exceptions. You cannot speak against the national security. You cannot speak against the country's secularism. Certain exceptions have been. The difference between what we have studied in schools and colleges and what we study in the professional courses is we are just going an extra mile and seeing what is the background of it. So as I mentioned in the introductory session, it is purely laws going to be approached with a minimum amount of memory, which you have to remember few things, and maximum amount of what? What? Common sense. You have to apply. Then, wait, is it hard? Is it hard to apply common sense? We'll try. Let's give it a try. Right? So that is where we stand. We'll start with the classes. And what was my request on the revision? What was my request on the revision? How you should give approach to the subject? Anything? Anyone? What? That is exams. I'm speaking about the revisions. Revision, how I want you to prepare for your law exams or law paper, not for law paper alone, for any paper for that matter. During this part alone, everybody went out of this. When physically you were present, mentally you were out. This, sorry? Yeah, exactly. She has heard it for twice in foundation once. Now again, she has heard it, so she has somehow got to it. Okay. So my kind request is, after every session, after every classes, please go home, spend 15 minutes, 20 minutes, whatever 5 or 10 pages which we see, please go through it once. You will definitely have doubts only when you go through for the second time. Okay. Then after we complete a lesson, we'll be having 18 lessons. Okay. After we complete one lesson, go through it, the entire lesson for once, spend 1 hour or something, right? Post to that. Then you will have your revision during your exams. 3 revisions if you do, you can comfortably go to your exam hall. So apart from that, which I can offer you is a revision in the class, a recap of the previous session, what we have seen, which will be in a short mode. Okay, right? Remember? Remember hearing this? Then why didn't you say? Right? So coming to the exams, we will again, after completing the syllabus, we'll go to the exam, how to prepare for your exams, how to perform in your exams, how to present all these things, including the section number part. Do not confidently write a wrong section number and expect full marks, right? Okay. So we'll go to the subject, right? So law, we have already seen a background of what it is. What is a law? Set of rules. Two, what does it say? Law is a set of rules. Why is this framed? To keep it as a paper in intermediate. Is it? Why? To follow. What if we don't follow? Punishable. What is the intent? The intent was to punish people. So they bring in law, ask whether see people are following it or not. If they don't follow, punish them. Now literally many laws are brought in, like for fining itself they have brought in. You know, Security Exchange Board of India, SEBI, you know, right? SEBI has given authority to stock exchanges to regulate listed companies. This they come up with the SOP, standard operating procedure. They have given one regulation, 1 day delay, 2000 rupees fine. So they will be keenly watching whether you are filing a submission lately. Okay, 1 day late. Okay, put 5,000. What the other stock exchange will be doing, NSE will be seeing through BSE's website. Okay, that person has charged. We should also charge. So literally, they have gone into for punishing, for fining, taking government revenue. All lawmakers have decided to do so. We are seeing it, right? So now leave out the present scenario. Let us go to the earlier scenario. Why law was there? Why law was enacted? So law, we say that it is a set of rules. What is this going to do? To follow or not to follow is a choice. And what it is? A set of rules which specifies do's and don'ts for every matter. Do's and don'ts is going to be there. You go for a ride. We have taken an example of a traffic rules. What it says, this you can do while driving, this you cannot do while driving, right? Which you should do but you are not doing, you are not following, which you shouldn't do. Law has prohibited that. Going into a no entry is prohibited, restricted. What we will do? We will happily go in that. Right. So, as we see, law is about only rules which says do's and don'ts. The peculiarity about law is law says do this. If you don't do that, it is an offense. Law says don't do this. You do this, it's an offense. So it works that way. Okay. So later we will see what is an offense under one of the topics. As of now, it's rules and regulations which is being formed. And if you go back to the, in case of LLB and all, they have a similar opening to a law. They say law is nothing but do's and don'ts, rules framed for human behavior. All this are given to artificial intelligence, is it? It is only for us. How, what you should do, how you should act, how you should behave, what you can do, what you cannot do. So all those are framed as law. And first thing, when we start studying about law, we have the understanding that it is a set of rules and regulations, do's and don'ts. The next thing which we have to come up to is, in India, which is the mother of all acts. It is Constitution of India. Constitution of India. You know what is Constitution? When was Constitution enacted? 1949. 1949. Everybody agrees? 50. Who's it? 50. 1950. Yes. Any other answer? 2013. Somebody. Today. Nobody. I'm giving you 4 options. You are not choosing the other 2. Right? So, we'll come back to that. We know Republic Day, right? What is the Republic Day? Constitution was formed. Followed. We started following Constitution. See, there were British law, okay, which we were under. We wanted that we will make our own laws. Okay. Then eventually we appointed who? Who? Dr. Periyar. Dr. B.R. Ambedkar, right? He was the chairman of the committee, and there were other people who were under him. There is a team which brought down the constitution which we are looking at. Constitution gives power to the lawmakers, government, parliament. Parliament doesn't have its inherent powers. From where it is going to derive its power? From Constitution of India. Constitution is the mother of all acts and laws in India. It is going to give power to the parliament to make laws for whatever it requires. State government to make laws, whatever it requires. In case of urgencies, when parliament and state assemblies are not in house, what happens? Urgent requirement is there to pass a law. What comes in? Ordinances. Who has the power to make ordinances? President and governor. President in case of central government matters and governor in state government matters. Who gives the power to them? Constitution of India. Article 123 to president, Article 213 to governor. So nobody comes with inherent powers. Nobody comes with inherent powers. Articles of this Constitution of India gives power to every person. Let it be governments, let it be individuals. Right to freedom of speech, which we are speaking about. Who gave? Constitution gave. So every day morning you have to take a constitution, read, Thanks for giving me freedom, rights, right? So that is how we are going to start with it. There are few rights which we are going to see. And to start with, what does the Constitution say? There is something called preamble for the act. Preamble. What is preamble? Any idea? What is a preamble? Print page. Preamble. We can say index page, no? Yes, yes. So preamble, only Constitution has a preamble. Any other act has preamble? All laws has preamble. All act will have preamble. See, preamble is nothing but you write an essay, you put in a first heading called introduction. You are going to write a story. Before that, you are going to say what is the story about. So preamble is nothing but is just giving you a trailer of what is going to be in there, right? So preamble is nothing but the intention of this law is what? Going to Companies Act. Preamble of Companies Act says an act to amend, consolidate laws relating to companies. So all act relating to the existing companies and new companies going to be incorporated. It is going to consolidate and make amends to the existing 1956 Act and putting into a new form is called 2013 Act. So it says, what is the purpose of this law? So similarly, preamble is going to be there for every other law. Any act is going to have a preamble. It will say, what is the purpose of this act? Similarly, Constitution is going to have a preamble. What does the preamble say? Is we, the people of India, this part, okay? We, the people of India, solemnly resolve to constitute India into an sovereign, socialist, secular, democratic republic. So that is why we call it as Republic Day. Okay? So we agree to certain matters and say what we are going to ensure. We will ensure justice, all sort of justice, social justice, political justice, economic justice. Right? So similarly, liberty of thought, expression, belief, equality of status of opportunity to promote equality among all, and fraternity assuring dignity of the individual and unity and the integrity of the nation. So fraternity is people of the same kind. So we will stay as Indians and go further. Right? So this is what we agree. So as citizens of India, we agree to move forward as a republic country. We will ensure that these all being provided is available in the country to all citizens. This is being made available, right? And before this just you have to see something like preamble here. Okay. Before that, the Indian Constitution is one of the lengthiest constitutions which we have seen, and it has a federal system. What do you mean by federal? Federal. Federal. Two. Yes. What is federal means here? Exactly. So there is state government and central government, union government. Central government சொல்லலாமா union government சொல்லலாம். You haven't been following news lately, right? Central government தான் சொல்லணுமா, மத்தியன்னு சொல்லணுமா, இல்ல ஒன்றியன்னு சொல்லணுமா? மத்திய தான் சொல்லணுமா? அப்ப நம்ம ஒன்றியனே சொல்லலாம். Okay. So federal is a state where there are two powers. One is central, other one is state. Okay. So India is a model where we have both central and state concurrently there. So certain matters central is going to act on it, certain matters state is going to have powers over it. So then we have, where we can find this, there is something called union list, state list, concurrent list. So these are lists where gives parliament the power to make laws. Now you are going to make a law. Recently, in the last class I have mentioned, what was the new law which was passed? Huh? பாரத் மட்டும் தெரியுது. பாரத்ல என்ன? பாரதிய Suraksha something, whatever it is. So they just passed new 3 laws. Indian Evidence Act was repealed and new Evidence Act is going to come. They don't want to call it as a Indian. Now they have got it to Bharatiya something. Okay. Indian Evidence Act, Criminal Procedure Code and Indian Penal Code. All these 3 things has changed now. Okay. Now, who gives the power to change all these things? Who changed this? How an act can be passed? Any act for that matter, how it comes to existence? A bill should be there. Then, அது எடுத்தோடனே அசன்ட்டுக்கு போயிடுவீங்க. எடுத்தோடனே தயிர் சாதம் தான், சாம்பார் ரசம்லாம் விட்டுறது. Who has the power to make laws? Parliament. Parliamentல 2 houses இருக்கு. Okay. So any bill will be presented to the parliament. Okay. Lok Sabha has to pass. Rajya Sabha has to pass. Then it comes to president for his assent. Once it gets his assent, it will be published in the official gazette and becomes effective. So that is how law is being passed. Right. So all these laws, how parliament has the power to make laws. Who gives the power? Constitutions give the power. Right. So these items fall under the union list. In case of any state laws which has to be made, state can pass it in state assembly. So it has a state list. There are certain matters called concurrent list where both state and central can pass laws. Right. So India is a federal system where both state and central exist. Right. So India, when you go and read the Constitution of India, it will say India is nothing but union of states. Now we call United States of America. There are multiple states. They call unitedly as America, USA. India is also similar, right? There are multiple states. This common name called India. That's the difference. Okay. Now, clear? Can we move forward? Okay. What is the purpose of this preamble or the whatever this constitution is made for? They want to make clear what is India up to and what are the citizens of India is going to be held with. So they say 4 points. Okay. It discloses the source of the constitution. Okay. So India is going to be the country where this constitution is going to be there and we are going to follow based on whatever it is. So it lays down the date of commencement of the constitution. We'll come to that. 3. It sets out the rights and freedom of which people of India wished to secure for themselves. Right. So when it came, we were under British rule, just out of British rule. We were expecting our own rights. That was being envisaged under this and declares the nature of the government as federal state. Right. Now, when it was adopted, so as people said, 1949 is where it is being adopted. When it came to practice, when it has came to practice as a Republic Day, it's 26th of January 1950. We declared ourselves that we are a republic, and then on we started practicing it. But the adoption date, because in our objective questions, they will have such questions when in our Constituent Assembly, they adopted it on 26th of November 1949, 1 year earlier. Okay, 26th November 1949, not 1 year earlier, it's literally 2 months. Okay, when it is adopted, it is 1949. When it came to practice, questions will not be asked as when it came to practice. Definitely they are going to only ask for adoption. 1949 is where it is adopted. Right. So we see that preamble is nothing but an opening of what it is into it. And there is one case law with respect to Kesavananda Bharati, state of Kerala. It's held that the Supreme Court has held that preamble is a part of the Constitution, is of extreme importance, and Constitution should be read and interpreted in the light of the grand and noble vision expressed in the preamble. However, the preamble is neither a source of power to legislature nor create any prohibition of powers. What is preamble? It's just giving an idea of what is into it. It is not restricted its powers to within the preamble. Okay, it's just like a trailer, as I told you. It just gives an idea of what it is into it and what is the nature of this legislation for what it is being brought in, but it never controls or restricts its powers. Okay, because this in this case of Kesavananda Bharati versus State of Kerala, they went on this preamble says only this thing. So whether the act can contain much more, it can contain. The article can have any number of, constitution may have any number of rights, powers and freedom which can be exercised. Not everything has to be given into the preamble. Okay, so that was the case here. Here, can you move forward? Just now we have seen what is the constitution, what is the type of the constitution in India, what is India as a federal state, what has been mentioned in the constitution, when what is adopted, and what is the purpose of the preamble, what it has said. Clear? Any doubts? Can we move forward? Now comes to the important and well-known part called fundamental rights. What are the fundamental rights? Basic rights. So, in foundation, I think they had very good introduction on this part of, I mean, when I mean foundation, it's foundation syllabus. Okay, you need not mean that the foundation classes which we are taken, right? So, in foundation syllabus, they have given this excellent opening that part 3 of the Constitution of India. Constitution is divided into parts 1, 2, 3, 4. Okay, third and fourth are important parts, where third part, part 3 of the Constitution says about fundamental rights. Okay, part 3 of the Constitution deals with fundamental rights. So there we have all our right to equality, all rights, freedom of speech, everything is coming under this category. Okay, so it has individually given what are the rights envisaged under the respective article. Is there any restriction to it, or you can freely exercise everything? Is there any exceptions to curtail you? As we speak, right to speech, you have an inherent right to speak anything and everything? No, you cannot go speak against your country's sovereignty, right? So similarly, restrictions has been made. So there is one other, we will be seeing it. There is one other thing where there should not be any discrimination with respect to religion, caste or creed, right? What does it mean? What does it mean? Right. So when I give a preference to you based on religion or caste or your gender, law will not accept it. Right? As before law, we are all equal. I do a theft, same thing. You do a theft, same thing. There is no difference between age, gender, or whatever qualification we have, nothing. So that is what it says. But the same government, what it does, you have anybody of you interested in UPSC, civil services? In civil services, they have given cutoff age. Okay. There are categories between which the age is going to be discriminated. So certain people can write up to 33. Certain people can write up to 35. Certain people cannot write above 28 itself. What they are doing now? What they are doing now? Aren't they discriminating? Can they do that? Excellent. So whoever does this, apart from the government, we will not accept. If the government does it, we'll accept. So there, they have given the provision saying that this section of the society are considered to be weaker section because they have been deprived of certain basic things since their early days before independence. So we have to have their representation as well. So if I give an equal opportunity, right now they will take years to come up. So I'm going to give some relaxations to them. So who is going to decide on that? Only the government. Government can make laws for the benefit of these people where they can discriminate. For what? What is the purpose? For the greater good. For the greater good to have as much as representation from their weaker section also. Right? For that, government can make laws. So this is how you also say equality, then you also have some inequality and justified inequality. Why this is, we cannot call this as an inequality because they justify with the reason that only for this reason we are making it. Okay, and now we are speaking after 50 plus years and 70 years has already gone, and still we are following that, which needs an revisit. But unfortunately, government had done it. We will see. We will have to see whether it will go through it or not, right? Because you just go and see literal examples where not recently, a couple of years back, there was a family which was considered to be an very affected, weaker section of the society. Now, the parents is already IAS. Okay, both of them are IAS. Their son is easily getting because of the concessions available to him. But there is other person who is by birth, he is from a different forward caste, but unfortunately he is unable to secure this place in the civil services because his cutoff is too high and he cannot meet it. The relaxation at that 1950 was different, had an intention that to uplift those people to make a even ground. Now it is the other way around. Now we have to say the other people by making amends to the law. Okay, that we don't know when it is going to happen. That is not a part of our syllabus also. So let's continue with whatever is given in our book, right? So fundamental rights are certain elementary rights, basic things, as you said, basic rights which everybody wants. Elementary rights as right to life, liberty, freedom of speech and freedom of faith and so on should be regarded as inviolable. What is inviolable? Nobody should violate you have a freedom of life, liberty, and you have freedom to move around. What if I'm going to detain you somebody? You are being violated of your rights. Now literally you are being violated of your rights, right? Isn't it? If you had an option, you would have moved out. But unfortunately, I am violating your right to freedom of movement and violating you by keeping in this. I cannot say it's a closed room, it's an open room. Right? So, while inviolable is should not be violated. These should be available for all. That is what it says. Fundamental rights is the Magna Carta of India. Magna Carta means it's the essence. It's the very essence. Fundamental rights was the very essence of this constitution. They wanted to provide to the citizens these rights, right? So there is a case law where E. Rayappa versus State of Tamil Nadu. The concept of equality, when we say it is equality, what is equality? On what terms you need equality? Equality before law, equality when you are approaching an interview, equality when you are being judged for something, equality for opportunities, right? So what sort of equalities is being available to you? Whether is there any refined list? Equality is available for 1, 2, 3, 4, 5 things. These heads alone, these parameters alone, everybody has to be treated equally. No, it is unbound. It can include anything. Equality is equality in all types. I cannot list everything individually. So in this case, they have clarified that, see, equality means equality of all sorts, including, it cannot be campaigned or confined to only these 5 items. Equality should be provided. No. Whenever new items comes, whether I have to use this lift, when everybody can use, equality comes in everything. Okay, subject to certain restrictions. So whether the items of equality has been mentioned, no. Anything comes, everywhere equality is going to be there. The concept is not going to be cabined, controlled, or confined to only certain matters. Everything is applicable to equality, right? The first article which we are going to see is on Article 14. Article 14 speaks about equality before law. So everybody is equal before law. That is what it wants us to insist. Okay, then in what manner equality before law, or the equal protection of law within the territory of India? What it is going to do? Prohibition of discrimination on grounds of religion, race, caste, sex, or place of birth. You are not going to be discriminated. This is what it insists. Everybody is same. Either you are born in Tamil Nadu, Maharashtra, law is not going to say as a different thing. Okay. Now, certain states has a practice of only a resident of that respective state can take certain positions. Is there discrimination? Why? So that also is being provided in the law itself. Okay. So exceptions as well as the rule is being given. First item where we are seeing equality is going to be ensured. There is no discrimination on based on certain categories. There are exceptions is being given under 361 of the same constitution. They have given exceptions to equality before law, where president or governor shall not be answerable to any court. They cannot, if in case of an individual is committing some mistake, what you can do? Courts can take cognizance over him. What is cognizance? Take action. Take action against him. But in case of president or governor of the state, he shall not be answerable. So they are giving few exceptions to the law of equality. What you should say? Equality, me, I am also an Indian citizen, president also an Indian citizen. You are arresting me, arresting him also, you cannot say. Because law itself provides them an exceptions under 361. No criminal proceeding whatsoever shall be instituted against president or governor. No civil proceeding will be claimed against governor or president during their tenure. Okay, I cannot go and ask governor has to pay me some amount. Being a governor, he has to pay me some amount. Okay, holding this position, he is subject to some civil claim. It cannot be encouraged by any court of law in India. So they have given only exception is what? President and governor is being given from, they are not answerable to the court. 2. No criminal proceedings can be instituted. No civil claims can be made against their office as president and governor. Remember these 3 things is enough. Right? Equality before law is there. Prohibition of discrimination on certain grounds is not available. Only exception is to president and governor on 3 matters. What are those? Not answerable to the court, criminal proceedings cannot be instituted, civil claims cannot be made against their officers as president and, right? Clear? Can you move forward? Yes? Next is on Article 15. This also speaks about the same prohibition of discrimination on certain grounds. They have given the list of them, religion, race, caste, sex, place of birth, or any of them. There can be any other things added to it. Okay, community, whatever it is. Okay, it is just like anything else. None of the above category. Any of them can be there, or there might be new instances of people bringing in something as a discriminative factor. Even that cannot be construed. The court will take cognizance of those. It is not present in Article 15. Article 15 gives only these 6 items. There is new one item we have identified. Whether we can go and discriminate based on that, court again will come into the picture and see. Okay. So what do they speak here? There they have spoke about the right to equality before law. Everybody can access to law. Everybody will be seen as a same person in law, every Indian citizen. Here they speak about the discrimination shall not be imposed on somebody for accessing few things. One, access to shops, public restaurants, hotels, or public places or entertainment. You cannot restrict somebody on the basis of that. Right? Two, the use of wells, tanks, bathing ghats, roads and places of public resort maintained wholly or partly out of the state funds or dedicated to the use of general public. So here they are just speaking about access to places. There is a common place. You cannot restrict somebody with the category of that. Right? So why all this was introduced? Have you seen this movie? Which movie? So Mamannan, what it is? Yeah, exactly. There would be a scene where in his childhood they would be accessing to a well where the other section of the society will start throwing stones at them, right? So there were practices where people restricted a section of the society not to access certain rights. Even now you go down south, there are still places where in tea shops you will not be given this glasses or tumblers. The section of the society is still given coconut shells. You wouldn't believe. I have seen it in my hand, in my eyes. We say we are secular, everything is being changed. We are still 70 years back in certain areas, which is an hard truth to digest. Right? So, these were there. Law wanted to make changes. They brought in. Nobody should be discriminated based on this. Should not be restricted access to these things. Commonwealth, water, bathing ghats. Right? So, for those, you should not be restricted. Right? And meaning of the second here is where they have said for the access of general public, you can have your personal well restricted. Okay, you have your at your home, or you have a temple where there is a well and people are getting access to it. You can restrict with it. Since it is your own property, you are not using public funds or state government funds to maintain it. Okay, that is how they differentiate in small ways. Okay, here they have given no citizen shall be on the grounds subject to any disability, liability, restriction or condition with regard to access to shops and use of wells is being clearly demarcated. Whether you can have any exceptions towards it, yes, exceptions has been given in the same article itself. 15 is the article. 15, 1 and 2 says this A and B. Okay, 1 and 2 is A and B, and say 1 is there and 2, and under 2 you have given these two rights. Okay, what you should not do, right? Then 13, 14, 3, 15, 3, 4, 5 gives about the exceptions. Whether you can impose such restriction, yes, when it says prevent a state from making any special provision for women and children. With respect to women and children, you can make some laws, restriction with respect to certain areas, and then nothing in this section shall prevent the state from making any special provision to advancement of any socially and educationally backward classes of the citizen of the scheduled caste, right? For the scheduled caste, for these people, for their upliftment, to have enough representation from their end also. At that point in time, they wanted to give certain relaxations that is also being allowed at that point in time, right? Then nothing in this article shall prevent the state from making any provisions by law for the advancement of socially and educationally backward same scheduled caste or the scheduled tribes for what? As far as special provisions relating to their admission to the educational institutions. Okay? You say everybody is equal. Educational institutions, this person is not getting enough marks because they have been into a different world. Their parents never went to school because you have been depriving them of their education at all. Right? So now he wants to go to school. Obviously, his parents are not educated and he wouldn't be having enough knowledge when compared to the other people of the same age. So there I'm going to make for scheduled caste or scheduled tribe, you make a reservation out of your total 100% capacity, minimum 25 should be given to them. Other you can give it to people based on merit. This can be made. So all these exceptions are made only for the greater good, not to discriminate. Not to discriminate based on something, only for the betterment of women and children or a section of the society which has been educationally and socially backward, to ensure that they also come up. They have made discrimination under the law. This is allowable. This is allowable. Right? Clear? Third, similar thing. Article 16 ensures equality of opportunity in matters of public employment. So in case of any public offices, when you go, you are making an application, a male, female, a person of different caste, a person of, obviously qualification cannot be brought in. They have not mentioned qualification because discrimination can be done through qualification, because I need a qualified person to a graduate who is qualified to take this work. I cannot put, you should not discriminate based on our qualification. We are also people. These are basic things which you cannot go for a discrimination. And now they say for a public employment. What is public employment? Government offices, public offices, when you apply, there will not be any discrimination. There should not be any discrimination between two parties, two persons, relating to taking up this employment or offering this employment to them. Right? So it says there shall be equality of opportunity for all citizens in matters relating to employment or appointment of any office under the state. They are not speaking about private. They are not speaking about, they cannot control private. Obviously, if you go, there are certain places you go, you can see only as you language, certain language speaking people only gather together. Okay, they want to employ only their friends and relatives. Whether the law is going to restrict them, no, you should not appoint people from your own state, appoint from a different state. Law cannot restrict private offices. It is only speaking about the public offices where the state can not discriminate based on those grounds. Then no citizen shall on the grounds of religion, race, caste, sex, decent place of birth, residence, or any of them be ineligible for or discriminated against in respect of any employment of office in the state. Same they have given with respect to the grounds, right? What are the exceptions? Similar to whatever we have seen, here also exceptions has been given for the first case where we have spoken. The residents of the certain state alone will be able to betterly understand the case there. The language that would help an advantage towards the same place. So there they may discriminate within the allowable thing. So these are not exceptions which was brought in later. It was part of the constitution itself. The article itself said, making any law prescribing all these classes of employment as to residents within the state. where this person has to reside within the state, they can make laws. One. Then the other categories are similar to what we have already seen, where reservation of appointments in with respect to the backward classes, yes, we can do. Then reservation relating to the scheduled caste and scheduled tribes, yes, the government should. What is the reason? To uplift them, to give an equal opportunity to them, they have done it. Okay, those were allowable. Then, by the operation of any law which provides that an incumbent of an office in connection with the affairs of any religious or denominational institution. Now we have something called this religious Aranalayathura. There is a, what is Aranalayathura, you know? The government has some ministry which is working on this temples and maintenance of these temples, benefit of all those people, right? So there, it is going to be a public office. In this public office, whether you can discriminate, they have kept some discrimination with respect to, in case if it is going to be a temple, a person from another religion, if being appointed, will it do justice to that religion, or the denomination of that religion would accept it? So it might bring in problems to the religion as such. Religious practice itself will be bound to some question. So those cases, they still allow to make small discriminations with respect to when this office requires a person of the same religion or any such discrimination, it still be allowed. Okay, so wherever it is there, this applies, right? Clear? Can we move forward? So what are the three articles which we have seen till now? Equality. Equality before law is Article 14. Article 15, prohibition on certain grounds, right? Then equality, right? Equality of opportunity for public office, employment or appointment in public offices. Exceptions again. So here we have seen that equality of opportunity will be provided to all the citizens irrespective of their all these grounds which we have spoken about while an appointment or taking an employment in public offices. Any government office I go, I will not be discriminated based on any of these grounds. It is what being seen. There are exceptions where you can go for discrimination. The government can go for discrimination. We are all speaking about public offices. The public offices may go for an exception where they can allow 1, 2, 3, 4 is one. First one is relating to residents of that state. Everybody has to be given equal opportunity irrespective of place of birth we are speaking. But this state prefers that a person who is speaking the same language would do better justice to this role. He is a local officer appointed in a corporation office. I am appointing it. Now we are facing this. Okay. Now you go to some public office. You speak in Tamil. He will not know. You now go to bank. We can rarely see people speaking Tamil. We are in Tamil Nadu. So we at least have this basic education. We have able to communicate. What about these people who are in their 70s, 80s? They don't know anything other than Tamil. How they are going to communicate with them? So here, with respect to the employment in public offices, if the government feels somebody in the same state who is a resident in the same state will do justice to this role, they can make exceptions to this prohibition. 2 and 3 relating to backward class of citizens and again scheduled tribes and scheduled caste, which we have already seen in similar cases earlier. They can still make discrimination for the greater good. Then fourth one is with respect to religion. So while holding certain offices in the state which is belonging to a certain religion or denominations of certain religion, it is better to have a person having same belief or religion into it. So those cases, they can still make discrimination towards appointment of those officers within the same religion or denomination of the same religion. Right? Clear? Can you move forward? Yes. So Article 17 speaks about abolition of untouchability. We have seen in our books, no, school books, untouchability is a what? தமிழ்ல என்ன தெரியும்ல? இன்னாமை ஒரு பாவச் செயல். Untouchability is a sin. So these, see, now we are seeing it as okay, 70 years after, what, where is untouchability now? But you have to imagine at 1950, the reason they want to bring one article on untouchability is where it was so prevalent at that point in time that people had this practice of years and years of untouchability. How to bring people out of it? Only way to include it in the law. You are practicing untouchability, I will say it is an offense under the article. The very first enactment which I bring in, I am saying that you are practicing untouchability, it is an offense. I can punish you. Right? So untouchability is abolished and its practice in any form is forbidden. The enforcement of any disability arising out of untouchability shall be an offense punishable under the law. That is what here it is an offense. If you are practicing, it is a purely offense. The person who is committing it shall be subject to punishment. The problem here is nobody has defined what is untouchability. What is untouchability? Nobody has defined. Certain categories says, certain general meaning says, even in our parent to study material, they would have mentioned it, saying by way of their birth in this certain section of the society, they are termed to be untouchability prevails. So these people, since being they are born from a certain section of the society, they are termed as untouchable. But whether there are any other categories, because people later then practice not only based on this, people doing certain work skills, they are also categorized as those people. Now we are enjoying haircut at a very dignified salon. AC is there. That person will charge you more than what you earn for a day. Sometimes we live, okay, I think barber is very easy thing. You can earn more, as much as what we earn for a 2 days in 1 day, right? So now he is being in certain saloons, you have to take his appointment whether he is available or not. Only then you can go. If you want that person, you have to take his appointment. Only then you have to go. Later then, before 70 years, they will treat him as okay, you should be only at the back door. You cannot come to my home through the front door. By his birth he was not there, but the act of profession which he is seeking, his livelihood, makes him an untouchable. So that was never being handled anywhere, but people understood that okay, all forms of, that is why they have said all forms of untouchability is being forbidden. You practice in any manner, you categorize people based on their type of weaker section which they are born, or what sort of work they do. Still, I don't care. You are practicing untouchability, I will punish you for that. Right? Clear? Then the abolition of titles, Article 18. What are those titles mean? Earlier, all our friends, British friends, gave us many titles. So they wanted to abolish all those things. Okay, Article 18 specifically said that no title not being a military or academic restriction shall be conferred by the state. Apart from your academic doctor or academic titles with respect to whatever you have earned, or military title major, lieutenant, right? All these titles shall hold good. Apart from that, all other title has to be taken out. No citizen of India shall accept any title from a foreign state. The restriction was brought in, okay, because they used to give zamindari, sir, all these are brought in from the other foreign state which was given to us, okay. So that shall be abolished. No person who is not a citizen of India while he holds any office of profit or trust under the state accept without the consent of the president any title of the foreign state. So any person who is not a citizen in India, now we have this Sir Mountbatten. So all these people were there. Okay, later they didn't leave in 1947 itself. There were people who were staying for a while, and during that period also, the person who is holding this office in India, right? And during that period, some foreign government has given him some title. He cannot accept until the President of India gives his assent to it, right? So that is what they say. No person holding any office or profit under the state shall, without the consent of the President, accept any present emolument. What is emolument? What is present? Present is gift. He should not accept any gift, emoluments in any mode. Any mode, it could be an monetary amendment or non-monetary, any sort of perquisites or office of any kind from any foreign state. So all these things have been prohibited and abolished from the inclusion of Article 18. Right? We have seen how many articles? 5 articles. What are those? Article 14, equality before law. Article 15, prohibition on certain grounds. We know what are the grounds. 3, opportunity, equal opportunity for employment in public offices. 4, abolition of untouchability, abolition of titles. Great. Okay. We will have a quick break and continue. Right. Right. So let's continue with the next article. Article 19. 19, very favorite article for us. Already we know few things about this, right? Article 19 speaks about protection of certain rights regarding freedom of speech. This is the heading. Okay, the book hasn't covered the headings, but to know, I have just covered the headings from the Constitution itself, so that we will have an understanding. There will be section headings for any act. Any act will have section headings, but there are headings where it is too misleading. If you go for Companies Act 2013, okay, there will be a section called 185. 185 says that loans to directors. Heading is loans to directors. The provision inside says no, you should not give loan to directors, right? So there are certain oxymoronic things. The heading will say something, in the provision they will say something, right? So just for the purpose of understanding, the section headings have been given. Protection of certain rights regarding freedom of speech, etc. is freedom of speech, freedom of assembly, freedom of forming association, movement, reside and settle, profession, occupation, trade and settle. So that is what they want to mean. Okay, this is the very basic element which we have been exercising even without knowing. Even without knowing, we are being exercising. Only our social studies, civics or something would have given the basic of this. All the citizens have the right to freedom of speech and expression. You can speak your heart out, express yourself. In case if you are not happy with some happening, all people now, if you are not happy with the what they do, open social media, put all their efforts in writing and note, posting it, and following it, how many likes have been, right? So Freedom of speech and expression in any form being allowed. Then freedom of assembly. What is assembly? To gather at some place. So the law says that to gather at a place without arms and ammunition. It is not like you are carrying all these guns and other things, ammunitions, going towards a place. Policeman stops you, asks, where are you going? See, freedom is there. Freedom of assembly is there. We are going there. Why you are detaining me? You cannot detain. So that freedom of assembly is freedom to assemble without arms and ammunition. Okay, peacefully is being allowed. What about Marina? Jallikattu, the protest. It was a right which was exercised. It was right which was exercised. People had the right to assemble without any violation of the other parts. They did. It was successful. The end of the thing we don't want to mention about. Okay. Now, assembly is there. Freedom to form association. What is freedom to form association? Form groups to associate yourself into a entity, right? To form public self-help groups, whatever the name may be. So you have the option to form association, represent yourself as a part of the association, right? All these are being allowed. Then freedom of movement, you can move, right? So all subject to restrictions. We will see the other restriction. You cannot say and go near Raj Bhavan and say that they have freedom of movement, allow me in. So you cannot ask those demands. Those were final students, said hi, I said hi, waved back hi. Right? So again, subject to certain restrictions, freedom of movement is there, and you need not be restricted for freedom of movement. Then freedom to reside and settle. Reside and settle. Anywhere in India you choose to move, reside and settle, you don't have any restriction to do. From Tamil Nadu, you want to go and settle in Mumbai, can do. But that never happens. Everybody in Mumbai wants to settle in Tamil. Right? So anywhere anywhere in India, if you want to move, there is no restrictions. Article provides you the freedom to move, settle, reside at any part of India. It is your right. Nobody can restrict that you cannot do. But you should not go to Pakistan occupied Kashmir and say that, hey, freedom is there, I'm going to stay here. Okay? Please don't do that. Okay? Freedom of profession, occupation, trade or business, whether it is there, yes. You can choose your profession, what trade you can do, nobody can restrict that. Now, let's assume you are a part of a partnership firm. Okay, let's assume you are a part of the partnership firm. I am a partner. Okay, I brought you into the firm. You have been working here for 3 years. Okay, now you want to go out and start a competitive business. I am saying that once you leave me for the next 5 years, you should not start a competitive business, whether it is acceptable. No? Yes? Why no? Because there is a freedom of profession, occupation, trade or business. I cannot restrict, nobody can restrict the other person saying that you should not carry on the same trade. But whether this freedom is fixed that? No. So here, there is a distinction. In Partnership Act, we will be seeing this. In contract also, we will be seeing that. Now, for the time being, it says this is common to all the citizens. They say that no citizen shall be deprived that you should not do this profession. You should not do this trade by way of any discrimination. Being in this part of the society, you should not be a teacher. You should not do this profession. No. Being born in this part of the society or being an man or woman, you should not do this profession. No, nobody can restrict you. You have the freedom to choose your profession, do a trade or business, which you can do. And again, you should not say that I have a freedom of profession, trade, I'm going to trade weapons. Right? Should not do that. Subject to restrictions again. Now, what are the restrictions here? However, not absolute and subject to reasonable restriction. All these are available subject to the reasonable restriction. Any of your rights which you are exercising, freedom of speech or expression, forming association or moving to a place, residing, whatever it is, business, it is not affecting these parts. It does not affect the security of the state, friendly relations with the foreign state, public order, decency and morality, contempt of the court, defamation. What? We are speaking somebody, or we have all social media, we can voice out for anything. Defaming somebody will not be taken easily. Okay? Now, there is a one specific political party, they have created n number of defamation suits because everybody is against them. Right? So, why? Though it is your right for freedom of speech and expression, it is defaming an person. So, they are going against you on those terms. Right? Incitement of an offense, sovereignty and integrity of India. Incitement is nothing but to tundudal. So, you are intimidating someone to commit an offense. You are provoking something by way of your freedom of expression. You are provoking somebody to commit an offense. Even that cannot be accepted. So you have all these rights of freedom subject to certain restriction until unless it does not affect any of this. You are still okay to exercise all your freedom provided under the law. Right? Clear? Any doubts? Can you move forward? Yes. There are number of case laws which was part of your book. I have just taken few. Okay. So in Tata Press Limited versus MTNL, the Supreme Court held that the commercial speech and advertisement, whether an advertisement is a right, I mean, this one of the organizations has given an speech or an advertisement promoting their product. They say that you should not do like this. No. It is a speech of expression. Whether it is affecting any of the other part, it has to be seen. You cannot restrict that they cannot advertise because it is a basic freedom of speech and expressions which they are exposing, not anything else. So the Supreme Court ruled that yes, and commercial speech and advertisement is part of freedom of speech. The other case is on the Union of India versus Naveen Jindal, where flying a national flag is like every citizen can have the right to fly his national flag, but also you have to follow the rules. You know, right? You cannot, as you wish, you cannot hoist the flag, keep it hoist every time, all along the day. There are certain procedures to be followed, right? That has to be followed. But whether somebody can be discriminated that you don't have the right to hoist the national flag or you don't have the right to salute it, right? Then in Prabhudat versus Union of India, Supreme Court held that right to know the news on information about the functioning of the government was included in the freedom of press. So this freedom which we are speaking about is not an exhaustive list. Okay, these are very basic classes. Okay, under this there are many things. Under this there are many things. Okay, so out of which we are speaking about few. Freedom of press is where press can ask questions about the functioning of the government. Government cannot say that it is not in our article. You cannot ask me this question. Why was RTI introduced? What is RTI? Right to information. Right? So, right to information. What do you know about right to information? Against whom you can request for information? Any of them. I am a private limited company. You can file and right to information against me? No. All public officers can be given. Whether you have to mention the requirement why you are requesting this information? Yes? Yes? Unfortunately, no. Okay? You need not give the reason why you need this information. You just say, I need this information. RTA allows you to, without any rationale, you need not say your rationale for what I am requiring this information. You need not say. You can just say that I need this information. Let's assume there is a tender which has been recently awarded. I need to know on what basis this tender is awarded. Okay. I can quote this reason or not, but still I can apply under RTA and get my response. So that how it is being available. It is a public office which information is transparent. I can demand information from those office through RTA, and there is some person called, and under RTA there is a person called Chief Information Officer. Okay, he is liable to take my request, ensure that the requested data is being shared with me within the stipulated time. Okay, RTA covers all these timelines as well, right? Clear? So the rights under this are differential manners, various types are there. We are just grouping under few categories here, right? Clear? Can we move forward? So 19 is one of the very well-known sections to articles to us, which we have seen, and subject to certain exceptions, you can exercise all those. Be few case laws we have seen, right? Now comes the good part of knowing certain legal language, right? Article 20, protection in respect of conviction for offences. The act article itself, only 3 lines would be there. Our book has given 3 paragraphs. Okay. So now, before going into all these 3 things under the notes, we'll have just few understanding about few things. One, what is an offense? Why do you call it as offense? What is an offense? Why do you call it as an offense? Sorry? Doesn't contain a lawful obligation. Right. Anyone else? Other one, there was another answer. Who is it? Opposed to legal system, against the law. Against the law, right? Right. Violating someone's right. Right? So, applying something which we learned the very first stage. Law is nothing but rules and regulations. What it says? Do's and don'ts. Okay. Law says that you should regularly file your income tax returns. It is a do. You should do that. What if you don't do it? Penalty shall be levied. Okay. Then law says you should not commit any tax evasion, siphoning of funds, suppressing of income. You should not do that. But you do that, it becomes an offense, right? So do's and don'ts are the basic things in any law. Companies Act, it says what can companies do, what cannot companies cannot. LLP, factories, what it should do. PF, ESI, what the registered person is expected to do under the Act. Remit the PF, ESI amount within 15th of the following month is the do. If you don't do that, penalty will apply. Right? So, basically, it's do's and don'ts. There is an act. There is act or commission. Commission means not this commission. Committing something. Committing. Okay? If you do an act or commit something which is against the law, as we say, against the legal system, law says you should not do this act or commit this act, but you do that, then you are at fault and you are committing an offense. Act says that you should not do that. Do not violate the traffic signal. They say don't, but still we do, then it's an offense. Now, foundation people should not answer. foundation people who has attended my classes should not answer, right? So that is one offense. Okay, that is one offense. If you have successfully done it, you have been successful in performing it. Offense, it is an offense, purely an offense. If you have successfully performed it, law cannot punish you. But you have failed in performing it successfully, law will punish you. Any idea? You should not answer. People, other people. There is one offense. Got the question? Got the question? You want to need to repeat? Sorry? Who was it? Yeah, excellent. So this is just a question where, what if in case if somebody is attempting a suicide, they are successful in committing, whether law would be able to punish them? No, not even in hell. Or what if they failed in committing it? Failed means they are still alive. They will be charged for committing suicide, and obviously they will be punished for it. Okay, right? So that is nothing to do with our syllabus. That was just a question to see what is an offense. When you commit, law says you should not do something, you do something, that is an offense. Law says don't do something, right? So offense is taken away. Who says it is an offense? How you identify it's an offense? So against the legal system, we say, against the legal system is defined through legislation. Act says, some rules or regulation says that this is do, this is don't. I am not following that, becomes an offense. So any offense is going to be set by the law itself. Committing this is an offense. Not performing this is an offense, law says. Now, let's assume today we are there. Today I am just having a snack. The cover is there, okay, the wrapper is there. I am just throwing on the road and moving. Okay. Tomorrow they bring in a new law saying that loitering in the public, throwing this waste in the public is an offense. Effective 20, what is tomorrow's date? 29. Effective 29, it is an offense. Now, tomorrow afternoon, one of the person goes through a CCTV footage and finds me throwing this paper. Okay, now can I be charged for this offense? Why? So the commission of the offense should be at that point in time where the law should have prescribed that as an offense. Okay, not earlier. Unless until the retrospective effect has been given. Not all laws. Retrospective effect, you know what is retrospective? To give it from a prior date. Okay, since so and so date it will be effective. So retrospective effect will not be given to laws as such. Only very few laws with me relating to certain tax laws sometimes. Okay, otherwise no law will be given retrospective effect. So that is being saved. An individual protection in respect of conviction of offense. First item which we are going to see is, you will not be termed charged for offense for which at the time of committing an offense it is not an offense under the law. Later it was become as a law that it is an offense, but while you committed it, it was not an offense. For that, whether you can be charged, myself, when I threw this paper wrapper, whether it was actually an offense, no. Only the next day the law came into force. Whether I can be incriminated for my earlier act before the act came in, no, I cannot be incriminated for that offense. That is called as ex post facto law when a offense can be charged is only from the effective date from which it was being charged as an offense, not before that. So it says no person shall be convicted of any offense except for violation of law in force at the time of the commission of the act charged as an offense. When this act is charged as an offense, only from then and then onwards, you can be charging it as an offense, not for a prior retrospective period, nor be subjected to greater penalty than that which might be inflicted under the law in force at the time of commission of the act. What is important here? Two things. Time of commission of the act is important. Whether that act is an offense during that time when you committed that act is important to see whether it is there or not. In this case, in my case, whether it is an offense, no, it is not an offense. So when you hear this ex post facto laws, you have to know whether the commission of the act, during the commission of the act, whether law has prescribed that as to be an offense or not. That decides whether you can be prosecuted or not. Okay, then clear? Any doubts? Ex post facto laws. Second, okay, so there is a movie called Double Jeopardy itself. It's an English movie. I don't know how many of you have seen it. There is a Tamil movie called Dost. Have you seen it? Dost. A Sharath Kumar movie. No? Raghuvaran will be his friend. No? It's not so good movie. Okay. So I'll just give you the brief background of the story. See, Sharath Kumar will be having a son. He is a single parent. His friend will be there. Raghuvaran and his family will be there. Okay. There will be one scene where Sharath Kumar and Raghuvaran will be there, and it will be as though as they wake up that Sharath Kumar has killed Raghuvaran. So he will move out from that place, and later he will be charged for that offense, saying that he has killed his friend Raghuvaran. Okay, he will be charged in jail and will be taking the imprisonment for 7 years or something. He will come back and go after his son to find his son. Okay, he has already missed his son for 7 years. He will go find his son and come to know that Raghuvaran is still alive. Actually, he didn't kill him, but already he has served the imprisonment for killing him. The climax would be an excellent climax where there will be a panel of judges sitting. Okay, Sharath Kumar will kill Raghuvaran there before the panel of judges. Now they will be asked whether he has to be again charged for killing. What is your answer? Yeah, again charged for killing. He should be again charged. Why? Why no? Already he has served his imprisonment for the offense which he has committed. So now it doesn't matter. Okay, the judge, I think it's Santana Bharati, I think he will say that he has already served the imprisonment for this, so this will not be considered as offense at all. So double jeopardy means the same, for a same offense, a person cannot be charged twice or prosecuted twice. Right? That is what double jeopardy means. Okay. Now, no person shall be prosecuted or punished for same offense more than once. That is what double jeopardy wants to mean to you. So, the protection under this clause is available only in proceedings before the court, because I'll just give you what is the reason. It's only before proceeding before the court. So, let's assume there is a father, Mr. A, who has been killed by somebody. Okay. His son of A comes and makes a complaint that Z is the person who killed my father. Please prosecute him. He prosecutes. Then he is being charged with 7 years of imprisonment. He comes out. Then A's wife also goes and says, he has killed my husband. Now charge him again. Will the court charge him? No. Obviously, we have the reason that no person shall be punished or prosecuted more than once for a same offense. Now, what about this? Is only respective to the court the imprisonments or this passed in the court. What about the administrative fines imposed on you? Repeative offender, we have people, right? Continuously who, say let's assume today I am violating a traffic signal. I am being charged. Next week also I am violating a traffic signal. I will be again charged. Same day, twice I am taking a traffic signal charge, right? So whether this can be applied, say only once you can charge me. I will violate all signals from now on. Can we take that? So that is why they restricted that the protection under this law is available only the proceeding before the court, law, or judicial tribunal. In other words, it's not available for the proceeding before the departmental and administrative authorities where, in case of tax evasion and all, obviously in case of a continuous evasion, so second time you are committing, obviously they are going to charge penalty. They cannot say this, already once I have did, for that you have charged a penalty. Now you should not do. Double jeopardy is available. I just read now in the constitution. You cannot charge me. Don't come there, read the provision there. It is not available to departmental and administrative proceedings, only to the court, judicial, law and tribunals it is available. Clear? Any doubts? Okay, don't remember those movie and write anything. Okay, double jeopardy is what the underlined line says, that is enough. Same offense, more than once, nobody can be prosecuted or punished. That's all. Clear? Clear? Can we move forward? Then self-incrimination. So whether you can be forced to incriminate yourself. Now we have to go to another movie. Mr. Raja Kanna. Which movie? Jai Bhim. So Raja Kanna has been compelled to incriminate against himself. Yes, I have committed. Accept that given statement that you have committed that. Nobody can be compelled to incriminate against themselves. Nobody can be compelled. That is what the provision says, that no person accused of offense shall be compelled to be a witness against himself. Say that, yes. Nobody can compel me, saying that, yes, I have committed the mistake. Willfully doing is a different thing, but I cannot be compelled. No compulsion can be given. It extends to the both oral and documentary evidence. Therefore, where a person is accused of an offense, if compelled to be a witness, then such compulsion should not result in giving an evidence against himself. So, by compulsion, you cannot make himself as an evidence to the offense. You cannot do. It is void. Court cannot take that as an evidence at all. Right? So, three things we have seen under Article 20. What it is? Protection against incrimination on certain matters. One is ex post facto laws, where you cannot be charged for a crime while at the time of the commission of the offense it is not an offense at all. Right? 2. Double jeopardy. No person can be prosecuted or punished for same offense more than once. 3. Nobody can be compelled to be a witness of, right, for his own case, to be witness or an evidence could be done. Right? All these three things comes under the category of protection. Right? Clear? Article 20. Any doubts? Can we move forward? Article 21. Right to life and personal liberty. Right to life and to right to live, to have a personal liberty, to move my hands like this. Right? So where we have seen the right to freedom of speech, where it includes all sort of speech. When I speak to people, when I write to people, when I question people, when I post in my social media, right? Everything comes under the right of speech. Similarly, the right to life and personal liberty includes all sort of rights which can be exercised by an individual as a citizen of India. So, no person shall be deprived of his life or personal liberty except according to the procedure established by law. So, law has set certain restrictions within which I can act. Within that, I can enjoy my life. I can enjoy my liberty. Liberty means what? Freedom. Freedom to be self of mine. I can act in such a way, right? So in Maneka Gandhi versus Union of India, the court has given the widest possible definition of interpretation. What is interpretation? What is interpretation? Interpretation of statutes. So the law has something, a language is a legal term. To understand what is the meaning of it, courts generally interpret. Interpret means put reasonability to it. See what is the intention of the law. They will see what is the intention of the law, interpret that what the act has come to say is, in a simpler language, they want to say what is the purpose of this law, what is the purpose of the language used here, right? So, small differences make changes. In law, why it is important to read every word is may, shall has a difference. May, shall. The word may is a prerogative. What do you mean by may? May. May and shall, what would be the difference? So I can say, you may continue after 9. What is after? What is the option available to you? You may or may not. It is with you. It's your prerogative to decide. Prerogative is the exercise of an option. I can do or not do. When I give you the option of may, you may stay back after 9. Is your prerogative. You can stay or not stay. What if I say you shall stay after 9? Means it is a must condition where that you have no option to decide over it. So these are small things. So when the court is going to interpret on certain matters, it will see whether the words used there, what sort of meaning it gives to the provision. So that is called interpretation. Interpretation of statutes. There is a lesson in CS, interpretation of statutes. Okay, how the courts will interpret. Right now, interpretation says right of life includes everything. Right of life includes whatever you come across in life. It is available to you. Right now, right of life includes within its ambits the right to live with human dignity. The Supreme Court held that the right of life defines not only the physical existence but also the quality of life. How to live, all it is left to you. Nobody is going to determine you should live only like this. The life and liberty is left to you, but only thing is you have to live with dignity, right? Otherwise, they are going to catch you in some offense or not. This right is an inclusive right, including the following. I've just covered few of it. There are many which is given under your syllabus. I've just given right to travel abroad. These are case laws against which they have taken a right of livelihood, right to shelter, privacy, right against handcuffing. So, sir, in case if you are just arrested for a civil offense, there is no necessity to handcuff you. Okay, so right to health and medical assistance, free legal aid. Have you seen free legal aid? So in some of the cases, they will ask whether anybody is going to represent you legally. They will say, I don't have anybody to represent. Okay, court shall appoint somebody to you, right? So free legal aid will be provided. That is a right here. Now, prisoner's right. A court held that the prisoner died due to beating by a police officer. His family is entitled to compensation, right? It's an unlawful act which has been committed. For that, he can demand a compensation. The family can demand a compensation. The PUCL versus Union of India, the Supreme Court held that telephone tapping is a serious invasion of individual rights. Telephone tapping, have you heard? So telephone tapping is illegal. SEBI, SEBI is a Securities Exchange Board of India, scares of insider trading. They wanted to tap telephones because they say that they suspected that the top management people through phone they are informing to the people to trade on those shares when the results are yet to be out. But central government said no. You find some other way to find whether they have committed fault or not. phone tapping we will not allow. SEBI was rejected this phone tapping request from the central government, seeking why it's going into violation of a personal privacy, right? So that is being taken out. Right to education, yes, right to education is a right along with the right of life and liberty. 21A, it was a later inclusion which allowed to have a mandatory education, compulsory education of elementary till the age of 14. Yeah, right to take, right? Thus, this provision makes only elementary education as a fundamental right and not a higher or professional education. You can still demand this to be a right. Clear? Any doubts? 19, 20, 21. Can you move forward? Right. So there are other couple of rights which we haven't extensively seen. Even our syllabus just mentions about this and what it is, right? We'll just know the crux of it, what it is for, and we will have it that way. You need not have everything to be done. So Article 23 and 24 speaks about rights against exploitation. These two are Article 23 and 24. What it says and what it preaches is what means. Right against exploitation means what? Exploitation is what? What is exploitation? You are exploiting me. Means what? Exploiting. Making use. Sorry? Bad use of somebody. Yes. So you are not treating them fairly. You are trying to exploit the resources or an individual for that matter. Everything put to an unfair use or bad use still comes to be an item of exploitation. Now it says prohibition of human traffic of human beings and forced labor. You cannot exploit somebody to be a forced labor in your institution. All Vijay movies, and there is another movie in Telugu where they will be taken to an mine. They will be working as the slaves. I didn't want to mention the movie. It's a very super hit movie, right? So, right. So whether it is allowed, no, it is exploitation. Right to exploitation not allowed. Prohibition of human trafficking and forced labor is an offense under article. Article says that you are prohibited. No person can be used as a forced labor or trafficking of human beings is not available. This right is available to both citizen and non-citizens. Okay, you cannot say hey, Indian citizen only you told. It is available to only Indian citizen. I am bringing people from other country and now I am using them as slave. Whether you can do that? No. It is available to. That is the peculiarity about the act. See, certain places we have given citizens the rights. Even we agree, our citizens will be having this right. Here, they are being human. They are not allowing, okay, not only for Indian, even if a non-citizen also is still available to them. Okay, our state may impose compulsory service of public services such as military service or social service. This is an exception where you can impose something on minimum this year. You know, there are certain countries which mandate that you have to have a military service, compulsory military service of certain number of years. Okay, they need something, right? So that employment of prohibition of employment of children in factories. Factories Act already covers it. From where factories are takes it from here only. So a person, children less than age of 14 shall not be employed in an office where dangerous activities or hazardous activities is being carried out. They cannot employ people below the age of 14. So that is what it says. Clear? So exploitation speaks about two things. One is forced labor or traffic of human beings. Two, employment of children in factories. Clear? Can you move forward? Yes. So there are other few articles under 25 to 28. There are 4. 25. These are just to remember. You need not have everything in your mind. And specific to articles. Okay. Now whether I have to remember all the article numbers which we have seen. Good song. Okay. Whether we have to remember the song or articles. Okay. Now Article 14, right to equality. 15, prohibition. We need not push ourselves to remember every article. If you have the revision today, it's like a story. Part 1, part 2, part 3. You will definitely at least remember at least 4 articles. That would be enough. So Article 14, right to equality, we know where it starts. Prohibition. Then comes the following activities. So now I would just ask you to remember Article 14, where it speaks about right to equality. Article 19, which is most important, which speaks about the freedom. And Article 20, which speaks about protection against certain this thing. So these are very key areas which I would request you to, because in question we may ask, what are the protection against the self-incrimination under Article 20? You know the answer, that these 3 things are there. If you don't know the article, what you will read? Okay, certain things you try to remember. If you remember all things, I will be happy. Because at this stage, you will be easy to remember. Okay, 8 articles, easy to remember. Once you start the sections, then we will forget what is in the first session. Okay, so we need not push so much for remembering the articles. It will come if you revise. It will come automatically if you revise. Okay, now 25 to 28, right to freedom of religion, all speaks about religion. All the points 25 to 28, 25, 26, 27, 28 speaks only about religion and related matters. How to remember? First 25 says that what are the rights available to you? Any citizen, any religion, you can, 1, freedom of conscience to know about the religion, to right to profess, practice and propagate. You can accept, practice that religion and propagate to somebody else. It is your right. It is your freedom. You have the freedom to choose any religion, know about it, admit yourself to that religion, practice that religion and propagate to benefit of that religion. Nobody is going to detain you or restrict you from doing that. Right? Freedom of religion is what is being given. Understood? You know, in Hindu uncodified law, unfortunately, it is not there for us. There are ways how you are going to follow a religion. This Hindu uncodified law says, how you can become a Hindu, how you can become a Christian. There is something called baptism. Is it? How about Hinduism or Islam? So every act has certain ways how to adopt the religion, how to take up a new religion and to practice it. Hinduism has kept it very simple. If you live as a Hinduism, you are a Hindu. You accept the practice of Hinduism, take Hinduism as a way of living. That's all. So the Hindu uncodified law has given numerous sections only to say that if you practice as a Hindu, you are a Hindu. It says, in case of a Muslim mother, Hindu parent, what is your religion? It has an extensive list of various combinations, probability, and to identify what is your religion, you can find out using this calculator, right? So even though if you are born Hindu, born Muslim, born Christian, nothing restricts you to accept, profess, propagate, or practice another religion. It is given under your constitution as a right to freedom, right? So any religion, and it all not only covers the religious belief, it also religious practices. You can take whatever the religious practices you want to adopt, you can do that, right? 26, 27, 28, again all relating to religion. Only thing is that is personal, individually you can try. Then here it relates to every religious dominations shall have following rights. So religious denomination is what? A particular group of religion and people, or they may form an association. Okay, they have rights to establish and maintain institutions for religious purpose, manage its own affairs, own and acquire movable and immovable property, administer such property under the law. Now we see this is from this Seva Sangam. Some religion will have this, and we have churches under the CSI. We have some Ekambareshwara temple. See, Ekambareshwara temple is in Kanchipuram. They have a property in Chetpet. They have managing the property. Who gives the right? Article 26 gives that a specific denomination of a religion, they have the right to form themselves as an association, have manage their own affairs, acquire movable and immovable property, and manage those properties is being given. Right? Clear? They can do that. 27 and 28 speaks. 27 speaks about, lays down that no person shall be compelled to pay any taxes. So this gives, now it speaks about other people. Being part of the society, I should not come and ask you, you pay to my religious trust. You should definitely pay. Can I ask you? No, I cannot ask you. I cannot demand. That is what it's being said. No person shall be compelled to pay any taxes for promotion or maintenance of any particular religious or religious denomination. Okay? Any public will not be demanded to contribute towards it. There is no compulsion. 1. 28. No religious instruction shall be provided in any educational institution wholly maintained in the state fund. So now there are schools here in T Nagar itself. During the summer holidays, they used to give lunch, juice, everything, and preach their religion. That's happened. Okay, so people also send their children there because school போனா நிம்மதியா இருப்பாங்க. Leave விட்டுட்டாங்க 1.5 மாசம். So now they send every day they go there, take their preachings from the other institution. It says that government out of state funds, state government schools, those cannot preach any religion towards that. Okay, so that is why it provides no religious instruction shall be provided where in any educational institution wholly maintained by the out of the state funds. Cannot do some religious instruction, please follow this religion. Private, we cannot restrict them, they will do. Public are restricted from making any religious instructions to the students or any matter. Right? Clear? Article 29, protection of interest of minorities. So it says the minority people, minorities, for minorities who doesn't have equivalent representation, they are in numbers, they are low, their interest can be protected. How? Any section of the citizens residing in the territory of India at any part bearing distinct language, script or culture of its own shall have the right to conserve the same. They can conserve the same. They cannot be demanded to say you should not follow this, follow our language. From now on, you should leave out your language, follow us, come join us and be with us. You have to follow only our language from now on. Nobody can be demanded. These people have the right to conserve their language, hold their positions there. Okay, no citizen shall be denied admission to any educational institution maintained by state or receiving aid out of state funds or grounds of only religion, race, caste. It has already been discussed, but still, for specific to the minorities, being a minority in certain section, let's assume down south there is a village where there is a minority part living in the same village outside the village. Now that village has only one school. The people from the village are accessing to it. This minority which is living out of the village trying to access the school, whether they can restrict them? No grounds they can restrict them. The minority have the rights to have access to these institutions. So protection of minority interest is also being taken up. Specifically, they wanted to add up. Okay, because all other individually we have given some rights. We have said discrimination. The reason why they want to emphasize and cover all sort of discrimination is people should not think that okay, this discrimination alone they have spoken in the act, so other things we can still do. No, any sort of any fine, any nature and style I cover in our constitution. Okay. Article 30, rights of minority establish and administer educational institution, similar to the other categories where the there can be exceptions made to it. They say all minorities, whether based on religion or language, shall have the right to establish and administer educational institution of their choice. They can, for their upliftment, for the minority people and their upliftment, they can still establish institutions for their upliftment. And what they can do, what they cannot do, gives that the state. What now? One important thing which we have, I should have said it earlier, where state. What is a state? State of Tamil Nadu. There is an article. See, the problem with our material, I mean the Parent Institute study material, is they want to bring in all languages, different articles, but the basics they have not brought in. Everywhere we are mentioning as a state, state, state. What is a state? Article 12. Article 12 defines state. What is a state? With respect to a Constitution of India, whenever you mention state, whenever you read a state, it refers to state of India, state of Tamil Nadu, local limits, whatever the municipal limits here, corporations, everything will be considered as a state. So wherever they mention as a state, states shall make laws, means with respect to India, the Indian government, with respect to Tamil Nadu, Tamil Nadu government, with respect to local municipality or corporation, the local municipality or corporation or local authorities will be considered as a language of state. Now, with respect to the minorities, the state shall, what they shall do, shall ensure that the amount fixed by or determined under the law for acquisition of such property. This is where, under compulsory acquisition, we are, we are happening, this metro rail comes into picture, and we need land to be acquired, certain things has to be, right? Certain house property has been acquired. Okay. When making such acquisition, being the minority, it is acquired from the minority, they should not be discriminated on the price. Whatever it is actually available to them, they should be paid. You cannot discriminate, since being it is an institution maintained by the minority, you cannot take advantage over it. So it says, you have to read from the last and go above. While making any law providing for compulsory acquisition of any property of an educational institution established and administered by the minority, states shall ensure that the amount fixed or determined under the law acquisition of such property is such as would not restrict or abrogate the right of the guaranteed. So whatever the guaranteed amount shall be available, they shall not be deprived of those amount. In case if it is a other person, I would have paid 50 lakhs. In case this is only a minority, I will pay only 35 lakhs. Such discrimination cannot be done by the state. State is going to acquire under compulsory acquisition. They cannot do so. Now, state shall not, in granting aid to educational institution, discriminate those institutions. So, this state is going to offer educational aid, some amount, some support to all educational institutions. It cannot discriminate or prohibit giving this institution being managed by minorities. So no discrimination can be taken at. So both the points speaks about discrimination. One is, while compulsory acquisition, you cannot discrimination on the guaranteed amount, being it is a minority asset, minority's property. Second, while providing some amount, providing aid, you cannot discriminate that it is being a minority institution, I will not provide, or I am going to discriminate about. Right? Clear? That comes to Article 30. Okay? So, any doubts till now? Any doubts till now? Clear? So, we'll stop with Article 30. Article 32 is one good article which speaks about right to constitutional remedies. Now we are all speaking about what? Freedom, right, everything. What in case if it is being affected? What is again is being affected? You are affected. Your right to freedom is affected. 9 is over. I am still holding you up. Your constitutional right is affected. What is the option available to you? 32, Article 32 is available to you. Right to constitutional remedies. Whenever your fundamental rights are affected, you can approach the legal system, court, to remedy for that. So what sort of remedies are available? Till what court you can approach? 32 provides access to Supreme Court on certain matters. Directly you can go to Supreme Court on certain matters. What are the matters? What are the cases? Few other movies we'll see in the next class. Okay? Any doubts so far? Can we wind up? Thank you then. Thanks for the patience.